All right, hello everybody. Today, today is going to be an international law conference. My name is Sami Ayad. I work as an internal communications manager at Al-Fihri Open University, and today's guest speaker is Mr. Karim Sultan, and he'll be talking about, like we said, international law and its principles. You may begin.
Hi everyone, thank you for attending. It's an honor for me to be presenting myself and the topic here today. I'm 28 years old. My name is Karim Sultan, as Sami just said. I have experience for, let's say, 5 years in the field. Studied for 4 years at the American University in Bosnia and Herzegovina. I majored in international law and diplomacy, comparative law as well. And I'd like to share with you some principles and basics regarding international law itself, what it is, how it has developed, its history. Like, I would like to share with you some specific stuff. Like, I would maybe tell you stuff about the history of the traditional international law, how did it come to play, how did it start, being active in the world. I'd also talk about the modern international law history. Then maybe I could go into discussing the sources of international law, subjects of international law, the principles, treaties. I'd like to concentrate a bit on treaties, what they are, how they're settled, maybe the peaceful settlements between nations, such as mediation, arbitration, going to court itself. How is it conducted, and the responsibility of states between all that. Now, in terms of all of this, I'd like to start talking about the history and how it has all started. What is international law, first of all, if you are to think about? So the first thing that you might want to consider when you talk about the history of international law is the nature and the definition itself of what it is. And lots of scholars urged to find a certain definition of what international law really means and how to define it, but they couldn't establish a proper definition. But I could say that nowadays it has a great influence to domestic law via international treaties. And for example, if I say take the United States of America, the European Union, any country, the UK exiting the European Union at the moment, all of them combined together, they have certain relations amongst one another. And for them to establish agreements, any sorts of agreements, they'll have to have something written, right? Codified. So that thing written is called international law. I know most of you are probably aware of this. So the states, for example, adopt, modify, and in some cases exclude international legal norms. And international law mainly referred as the creation of the Western nations, because without being, like, the discovery of land all the way back in ancient times led to the creation of something to govern the relationships between those countries, and that is international law. Now, the history of all these ancient times. So the written international law is more than around 1,000 years old, for instance. And we're talking about the ancient international law. And the oldest international law documents are guarded at the Louvre in Paris, all right, in Paris, as part of the exhibition, The Beginnings of Writing. So it all started back, I wouldn't say started in Paris, but started with Roman law, started with all that civil law, but now they're stored in Paris, the documentation, all right? And the most important memories of human civilization are connected to the ancient Mesopotamia, and the oldest monuments are from the 30th to 25th century before Christ. Now, if I'm to talk about how it all started, I want to mention the Roman Empire. Had a great influence to the creation of international law, and many of the concepts that are used today are derived from Roman language, for instance, Latin, all right, for example. So I would give you an example of something called Jus Gentium, which means the law of nations. It was invented by the Romans to govern the status of foreigners and the relations between foreigners and Roman citizens. So in accordance with the Greeks, all right, and the Greek concept of natural law, which they adopted, the Romans conceived of the Jus Gentium as having a universal application, which in modern language means international law. Now, I can go all day and talk to you about what international law is and go in further detail about it, but I would maybe skip now and talk to you about the history of modern international law. So that was ancient, how it came up, how did it start, discovery of land with like major sea voyagers like Vasco da Gama, and discovery of India and America and all that. That is all relevant to the creation. But now if we talk about the history of modern international law, we have to talk about geographical discovery, what I'm just mentioning at the moment. The possibility of colonization and world trade formed the picture of Western European countries. Now, we can mention two very important names, such as Alberto Gentili, who is an Italian scholar. He had a great influence on international law, wrote various books talking about it. He provided a comprehensive discussion on the law of war, for instance, which, by the way, was one of the most important things back then, also with the treaties themselves. So, like, back then, international law was sought for the sake of war. How to stop a war? What are the laws of war? Because, believe it or not, even when countries attack one another, back then, there were certain laws that would prevent, for example, the destruction of nature, that would prevent war crimes. And for example, now we have tons of war criminals in The Hague that are awaiting, their penalties or criminal convictions and jurisdictions and all that. So all this results from this thing called international law. How else are you supposed to convict them or provide them with a sentence without you having a certain body of law codified? But then this raises a very important question. Do we actually have a law that actually says, okay, this is the codified international law? We don't. So the important part is international law isn't written. It's more scattered and separated between agreements, lots of agreements between different countries. And this will be talked about more when I start talking about and explaining what treaties are. Treaties are agreements, bilateral, multilateral, unilateral even. There are unilateral agreements between countries. So this is very important for you to know. Now, it's very important that I talk to you about the Monroe Doctrine. So this was enunciated by the president called James Monroe in his message in 1923, specifically on the 2nd of December, to the Congress. Now, he stated that the old world and the new world had different systems, and those systems must remain distinct from one another. And what does this mean? So President Monroe made four very important points, basic points. Number one, and I will talk solely about number one because it's the most relevant one to my topic today. The United States would not interfere in the internal affairs of or the wars between European powers. Now, this was all the way back in 1923. This is modern international law, where international law was actually a thing because there was communication. The president could come out and, discuss relations and international relations and international law are very interrelated. So he indicated, and this is the point one that he mentioned, that the United States would not interfere in the internal affairs of or the wars between European powers. So with this, he established some sort of an agreement with other countries saying, all right, listen, you guys can attack one another, but I'm not interfering in anything. So by this, he kind of established a unilateral agreement. Number two, he said that the United States recognized and would not interfere with existing colonies and dependencies in the Western Hemisphere. So any colonization ongoing, the USA will not interfere. This is also an agreement. And number three, the Western Hemisphere was close to future colonization, and which is not so important for the moment. And number four, this is very important. Any attempt by a European power to oppress or control any nation in the Western Hemisphere would be viewed as a hostile act against the United States. So it's not a threat, but this is President Monroe saying, all right, listen, we're out of your business. But if you interfere with our business, then we would, take action. So this is more of indicating his stance towards foreign intervention. So this is also a part of, why am I saying this? Because this is how scholars and legislators and lawmakers and everyone start to understand the importance of international law as the world grows in terms of colonization back then, and in terms of like the discovery of new countries and the arising of wars. Take now, all right? Now, for instance, the European Union with the COVID-19 issue. This is a real life example. The COVID-19 coronavirus pandemic. The European Union, well, some of the countries in the European Union have unified a body of laws and rules relevant to the treatment of COVID-19 and how national laws have to bind by international. But there are some countries that refuse. For example, the city of Barcelona. Anyone coming from Barcelona going to the UK at the very moment, or from Spain, matter of fact, has to go into quarantine for 2 weeks. All right. Now, the UK isn't part of the EU, but technically it still is until next year. But they have certain laws and rules that they have to abide by. That is very important. So that is very important to consider. Who gave them the right to do this? The EU. But then there are other countries, such as Greece, that have a curfew and a lockdown after midnight. So, for example, partying and clubbing is reduced. So these are called little national laws of a certain country. However, national laws can't be so different from the body of laws that they belong to internationally. This means that if the European Union as a whole has a certain law, and by the way, there is the European Union, I don't know, there are so many conventions and laws and treaties between European Union countries that they have to agree upon, and all of them have to, stick to these laws. And then there are national laws that countries refer to internally. I'll give you another example. Where has international law shown to have a very, very important point? Think about a person a person whose parents are from different countries committing a crime in a completely different country with a second person that is also from a whole different country. So where are you going to, for example, prosecute this person? So an Italian goes to the US, commits a crime, kills someone who's from somewhere in Africa. Who has the right to claim jurisdiction and authority? Who sets these things? It's very important for you to understand that this wouldn't have been known unless international law took place. Now, to get back to the point, I'd like to talk to you, for instance, now about the sources of international law. There are various, all right? There are many differences between examples of domestic laws and sources of domestic law, and then also sources of international law. Domestic law usually provides a hierarchy of norms and a basic catalog of sources and legal norms. But in contrast to that, international law isn't so easily accessible because, as I said before, there isn't a body of law, a book, a codified law that says, okay, this is the international law that you should look up to if there's an international issue. Because nowadays, almost everything is international in accordance with all the foreign businesses, the interaction between countries. Everything we do is just relevant to another country. So international law is basically part of our daily lives. If you purchase something from Amazon, that by itself has international law being part of it. So you are dealing with international law more than you think. If you study in a different school that is not, for example, if you study in an Irish school but that is not in Ireland, you are dealing with international law. Or maybe not yourself, but the people working over there are dealing with international law because they have to conduct dealings with Ireland themselves. And what will apply if there's an issue? How will you solve that without international law? You wouldn't be able to. Now, international law is derived from various sources, and the commonly accepted list of the sources is provided in Article 38, Section 1 of the Statute of the International Law of Justice. You can find that on the internet. Now, it is an annex, by the way, to the Charter of the United Nations, if you don't know what that is. There's no formal hierarchy between the sources of international law. You can't give, for example, can't give more importance to one source than the other. Like, for example, in national law, it's the Constitution. That's the first thing you look at. So if there's an issue, the Constitution is what declares it, and then you look at the local laws and whatever. But at the beginning, in international law, you don't have something to go up to and look at. Okay, this is my main document, and this is what I have to rely on. There are different things that you have to look at the same time, simultaneously. The first thing, the court. Its function is to decide in accordance with international law such disputes as are submitted to it. Now, what are we talking about? International conventions, all right? International customs, the general principles of law. And all of this, of course, has to be subject to the provisions of Article 59, judicial decisions, and the teachings of the most highly qualified publicists. So now, let's talk about international conventions. Now, the term of international convention in the statute refers to all of the bilateral and multilateral treaties. Now, before I go more in depth into this, I'd like to talk to you about this. Bilateral and multilateral treaties, what are they? Now, bilateral treaties are agreements between two countries. So let's say you've got Denmark and Finland, which are very close to one another, or even, let's say, I don't know, Finland and any country, the UK. They have an agreement between one another about, let's say, trade. So tax law. So they, for instance, excuse me, they, for instance, have an agreement that they don't charge taxes for one another when they import certain goods and services. That's a bilateral agreement, which also means a treaty. But then there are multilateral treaties out there that are deposited with the Secretary General and published by the Secretariat of the United Nations. And they're also, by the way, all available online, so you can look up any multinational treaties that you are interested in and look them up. There are, like, let's say 5 countries come onto an agreement that they will, let's say the Nordic countries, which is, by the way, Norway, Denmark, Sweden, Finland, Iceland, and I don't know what else. They agree that they will not, the same example, charge tax to one another in terms of importation of goods. That there is an international agreement, which is more likely referred to as a multilateral treaty. If I talk to you now about, for example, the general principles of law that are recognized by nations, and most states, most independent states, in terms of international law, abide by these basic, I would say, go-to nations. So now you've got, let's say, 7 to 8 principles that are very important in almost every treaty, whether it is bilateral or multilateral. All right. So you've got the prohibition of the threat or use of force, unlike how it was in ancient times. The duty to settle disputes peacefully. So you always have to seek to settle disputes peacefully prior to going to court. What do I mean? Even in the most simple or the simplest contracts that you have between parties, ignore international law. If you have an agreement with someone in the same country where national law applies, not international, in your contracts, most of the contracts these days have alternative dispute resolution means of solving issues and problems without going to court. So you seek mediation or arbitration, for example. Those are the 2 most common alternative dispute resolution methods. So this is what I mean by settling disputes peacefully, because why go to court if you can arbitrate or mediate your way into an agreement? There's also a duty of non-intervention and a duty to cooperate. If, for example, NATO, look at NATO. Any member, and this is in the law, any member of NATO, any member country of NATO that is, for example, attacked, all the other countries are bound to help that country. Of course, it's not as simple as I'm saying it now, but to a certain extent, This is the way it is. Principle of equal rights and self-determination of peoples. Principle of sovereign equality of states, and the principle of good faith. So those are kind of like 7 different principles that international law foreshadows and establishes, puts into order for every country out there that belongs to any treaty. Now, this is not a rule of, like, it is a rule of thumb, but it doesn't really apply all the time. There are always exceptions to everything. Now, if I would like to talk to you about something also an accessory to international law, what we look at when we look at international law, other than the main sources of law, other like codified law, the treaties, the views and of experts or stuff like that, we don't look at that only. We look at something called the soft law. And yes, soft law means instruments which do not have any legally binding force, or whose force binding is weaker than the binding force of real sources, all right? For example, the final documents of conferences are typical forms of soft law. And soft law has a great importance in international law, and even the application is quite favorable by states. And how do I define it? That's very difficult, but I would rather say that soft laws are, in the words of Shelton, normative provisions contained in non-binding texts. Like I would say is some form of tradition, like, hey, it's been done this way all the time. Now look at common law, for example. You know how the law is divided into 2 very important basic parts of law. Every country either follows common law or civil law. We don't have a country that follows both, not that I know of. Now, common law is not a written law. I mean, they have written laws, but they don't look at them. So let's say we live in the United States where common law, or the UK where common law is applied. What is it that the courts look at when there is a case that is ongoing? They look at previous cases, all right? Common law is case law. They look at X cases, and they're called precedents, all right? Not presidents, precedents with a C. So they look at precedents to see how similar cases have been proceeded upon back in the days. So lawyers would look at previously older cases and try to find any case that is exactly the same as the one that they are dealing with at the very moment, or one that is very similar. And they would present their arguments to the judge, telling him or her, okay, so this is how it was done for the same view, for the same type of case. Let's do the same thing. Let's apply the same thing to my case, because why not? Because this is how we've been doing things, right? So this is common law. And by the way, this explanation is very simple, and I meant to do it as simple as I'm doing it now for all the audience that is attending or will watch the video later that are non-lawyers. So it's much easier for you to understand if I speak in simplicity rather than I talk to you in codified language. Then you've got the civil law. Civil law, for instance, is most countries in Europe abide by civil law, for example. What is civil law? Civil law is one that comes from Roman law, more relevant to both of them come from Roman law, but civil law is codified. It's written law. So when you go to court, judges look at the law, find the law applicable to the case, present it, and hopefully win the case. Now, of course, it's not as simple as it is, because sometimes a certain law doesn't apply, that law doesn't apply, this law doesn't apply. The devil's advocate, knowing what the other lawyer would say so you can, have a counter argument, that too is very important. Why am I saying this? Because if you're studying international law, you need to find out, you need to understand the differences between common and civil, and what would you prefer to practice. If you're asking me about my personal experience, which I would love to share with you, I've been practicing civil law all my life. So when I say all my life, I mean from the day I graduated. When I was 25 years old, that was 5 years ago, I graduated and I started working as a civil lawyer. But now, do I prefer civil law over common law? No, because all the drama that you see on TV, which by the way isn't true, none of that suit stuff that you watch is actually true. It's much more different than how it is. All the drama that happens in court happens in common law, where the judge, claims order, and the lawyer stands up and argues and there's a surprise witness coming and stuff like that, all that happens in common law. And the objections, and that's all in common law. Soft law, like civil law, is more like, it's more soft. It's more the judge does everything. The jury. So in common law, there's a jury. In civil law cases, most of the time, you have no jury. It's the judge who decides. But in common law, it is the jury that decides. The 12 men or women that are sitting on the bench on the side, on the right side that you see on TV, those are the ones that present the verdict. And then the judge reviews it, and then they say, but like they don't tell the judge, okay, give him 5 years, give him 10 years. No, they just say guilty or not guilty. They don't, nothing else. And then the rest is on the judge to do. So in civil law is the complete opposite. Lawyers argue, the judge gets to decide everything. So some people always argue that common law is less fair, because why put 12 people that are not lawyers to decide my fate? They don't know anything about the law. Some people also argue that civil law shouldn't be judged by only one judge, or 3 or 5, or sometimes 7 and 9, because then it's biased if only one person decides my fate. So there are many discussions and arguments between common law and civil law, which one is better. And the real answer is that there isn't one that's better. There are pros and cons and ups and downs for both these kinds of laws. And I'm talking about common law and civil law because in order for you to study international law and to know what it is, you have to know what civil law is. You have to know what common law is, the differences between them. That's what we do in the first year. This is something that you have to learn every single time, every single day you start to, or you choose to study international law. Now, international law became more and more important in international relations, and the amount of international conventions, as well as legal norms, has been multiplied in the last centuries. Now, until the 19th century, law was only dependent on the will of sovereign states and was accepted by the national authorities. All right. What else can I talk to you about? If I talk to, I think this will be interesting. Statehood. So for a legal system, in legal system entities, individuals and companies can possess legal enforceable rights and duties. So the domestic law recognizes them as a legal person possessing the capacity to have and to maintain certain rights and being subject to perform specific duties. So the question raised here is, which entities have legal personality? I have a legal personality. Does a company have a legal personality? Now, without legal personality, institutions and other groups cannot operate. States, the criteria of statehood. What is a state? For you to be member of, or just to have international law apply to you, you have to be a state. But what is a state? So the criteria of statehood derived from the Montevideo Convention of 1933, which is available online. A state as a person of international should pass the following qualifications. So there should be a permanent population, obviously, a defined territory, geographical territory, a government, capacity to enter into relations with other states. So those 4 things are very important for you to be a state. If you want to have a bilateral treaty with another country, or a multilateral treaty, you gotta have all these 4 basic requirements. So a permanent population, of course, a defined territory, a government, and a capacity to enter into relations with other states. And what I mean by capacity, I mean in normal language, non-legal language, capacity is like being able to. So capacity to enter into relations with other states is being able to enter into relations with other states, which is subjective. Now, what else I could mention here? Maybe the recognition of governments, that is completely different from the recognition of states. There are 2 completely different issues. So the government cannot be recognized without the recognition of the state as a legal person. So you cannot have a government without having a state. But the state can be recognized without the recognition of the government. You've got, what else? The Sovereign Order of Malta, for instance. The Sovereign Order of Malta is a religious order of the Catholic Church since 1113 and a subject of international law. The Sovereign Order of Malta has diplomatic relations with over 100 states. So what is this? This is an international treaty, a multilateral treaty somehow, as well as the European Union, and permanent observer status at the United Nations. Now it is neutral, impartial, and apolitical. And today, the Order of Malta is active in 120 countries, caring for people in need through its medical, social, and humanitarian works. This comes from me to give you another example. If you look at famous NGOs such as the OSCE and the UNDP or the UNHCR and the other, Italian NGOs, I forgot the name right now, but there are many out there that, help assist refugees, asylum seekers, migrants, immigrants, whatever it is. How do they operate? So they operate based on international law. There isn't one country, well, there is a main country, but there isn't one country that makes these, laws and directs these NGOs to work, because they're everywhere. Every single country in the world, perhaps the United Nations operates in almost every single country in the world. How is the United Nations operated by? International law. But then the international law isn't written. So how do we know? So the United Nations operates based on the agreement of various countries together, what they establish in terms of who to help, who is qualified to be helped, who sets this order, who sets this law, international law. Now, you've also got the International Committee of the Red Cross. This is something else that I could say, which is a sui generis legal person of international law. So the International Committee of the Red Cross is regarded as a legal person. And by the way, some companies are also regarded as legal persons. And that's why this comes up to company law as an idea, just to give you an insight to some other type of law other than international. Why do some companies choose to decide to be limited liability rather than other? So a lot of companies you will see in any country that you are in at the moment that they're limited liability. Actually, most of the companies that I've seen are limited liability or stock. But what does a limited liability company means? Like, if there's an issue between, let's say, this company goes bankrupt, it can never fire back on your personal belongings. So the company goes into bankruptcy or insolvency, but it can never get to you personally. It cannot, for example, get to your personal belongings like your apartment or your car or your phone or your TV or whatever. So it doesn't get you. So a lot of companies choose to start up limited liability companies rather than other forms of companies, just to avoid being directed. So this is that barrier. Anyway, this was a side thing other than international law. The principles of international law, there's no laxative list of legal sources that I could talk to you about the governing principles, but there are documents that can serve as table of principles. Like you can look at the UN Charter, for instance, and the duty to cooperate, Article 55 and 56 of the UN Charter, Article 2, Article 2 of the Chapter 4, Section 3, subsections 1 and 7 of Article 2 of the UN Charter. So look up the UN Charter to understand the legal sources that govern the principles of international law. But then what are principles of international law before you get into that? A fundamental, primary, or general law, or truth from which others are derived, an adopted rule or method for application in section. Now, a fundamental truth or proposition that serves as the foundation for a system of belief or behavior or for a chain of reasoning. Now, at international law, we're talking about, for instance, governing principles that affect to the practice of certain countries. The state should comply with them in order to maintain peace and ensure the quality of the relations. So we have to separate the principles generally. So we've got general principles of fairness and justice that are applied universally in legal systems around the world, whether international or national law, and the governing principles of international law themselves. You've got the principle of sovereign equality of states. Sovereignty means supreme and independent power or authority in government as possessed or claimed by a state or community, the equality or state being sovereign. So, or having supreme power or authority. Now, the principle of sovereign equality of states is one of the oldest principles of international law. It first appeared in Westphalian Treaty in 1648, and the national sovereignty of states has been expanded to the territorial integrity as well. And the full sovereignty includes several factors, such as judicial equality, respect personality of other states. I need to talk to you about the United States of America in terms of their legal systems. Ever wondered why, for example, you've got the legislative, the executive, and the judiciary, the three different powers in the United States governing? Why don't we have just the president giving out orders? So let me give you an example. When you have a president that wants to pass a law, or the legislative body that wants to pass the law, or the courts, all right? What happens is that the other two have to approve it. So you need to have 66.6% approval. So at least two bodies have to approve it for a law to get out there. Another thing, when you are in a civil law court and you have judges, why aren't there even number of judges? So we don't get into a clash. Imagine having two judges claiming guilty and two judges claiming innocence. That will be an issue. So we always have 1, 3, 5, 7, 9, 11, mostly 3 and 1. What else I could talk to you about in terms of maybe the duty of non-intervention, as in every state has an inalienable right to choose its political, economic, social, and cultural systems without interference in any form by another state. This is a very gray area. This is basically saying that certain countries are free to do whatever they want in terms of their laws. But then this isn't very stable, because if you're a country that belongs to the European Union or any other union, and by the way, every country has gone into treaties, they have to somehow abide by those treaties. And the problem arises if, for example, if a certain country has very strict laws, for example, they have a law on execution. So they abide by executing people in terms of criminals and stuff like that. But then the body of law that they belong to opposes that. There'll be a problem, because then if you're going to court invoking international law, and if you have a treaty with such international law, you can't invoke the execution. You can't enforce it because you're a member of a body of law that prohibits it. So that's why this duty of non-intervention is somehow in the gray area. You can't have your own law without considering other laws or the bodies that you belong to, or the conventions or the treaties. Basically, you have various laws and treaties out there. You can look at the Vienna Convention on the Law of Treaties. How are treaties made? Who makes them? What are the requirements for a treaty to be passed? You can also look at the Vienna Convention on the Law of Treaties between international organizations and states, and by the way, which is not yet in force since 1986. Basically, these are the basics of international laws, what they are, all that. Now, my experience, I'll answer all your questions. I'll answer all your questions in a bit. Just allow me to finish, please. So the first thing that I would want to talk to you about is my experience. I have had the experience to work in Algeria. I have had the experience to work in Libya, in Bosnia, in Austria. And it was one hell of a ride. And I still work as a lawyer. And I don't plan to retire anytime soon. I'm very young for that. So now, what I want to tell you is the laws that I faced are very much similar, because the countries where I worked so far are all abiding by civil law. So when I go to let's say I worked in Algeria, and I abide by the civil law. If I move to any country with civil law, I'm not saying that I will know it all, but I would not struggle as much as if I moved to a country that is about common law, that supports common law, because then the whole thing changes. What I plan to do is one day I would love to work as a lawyer in a common law country for me to experience both and for me to actually feel the principles of international law in full, because now I've seen how it's like in the civil law countries. I have an idea of it's in the common law, but I want to work and get the experience from it. Anyway, this is it for today. I hope you guys enjoyed. I'd like you to maybe provide with me with any questions that you have in terms of this lecture. Anyway, please go ahead. Let me see. Can we civil law, the mother of laws, or the base of all laws? Civil law, the mother of laws, or the base of, what do you mean? Can we know how the verdict comes up with a decision as a group? Can you explain to me, Ahmed, what do you mean by this question? I don't know if he's still here, so I don't think he's still here. Any questions, anyone? If you have any questions, please, I'm right here.
If anyone has any questions, they can write their questions in the chat box.
I guess not.
All right then, since thank you very much, Mr. Sultan. This will be the end of our meeting. We are hosting this recording live on our Facebook page, and we'll also be posting this full session on our YouTube page. Once again, thank you and goodbye.
Thank you very much. Have a good day.
You too.